All right. I'm back, finally. I really need to tighten the screw on my microphone, I think. Keep it in the position I want. That's better. Sorry if that was noisy for you guys. But yeah, so welcome. For those of you who are new, hi, I'm Joe. I'm an attorney. I'm licensed to practice in the state of Utah. And today we are talking about a case that, for now at least, is in Illinois. And then we will probably talk about a case that's in Idaho. We'll see what the time looks like, basically. So, Linux guy, good to see you, as always. Gonna give people a little time to get in before we jump into the meat and potatoes of it. Um, And I do have a request. Linz, hello. Since I'm covering two topics today and I tend to forget, remind me to basically mark down the time when we switch topics so that I can put a timestamp in for people on the replay crew. And if you're on the replay crew, well, hopefully I have it in. But either way, we love you. Thanks for being here. So, Tara Gee or G, thanks for being here. And Shelly and Kevin and Victor and Dave. Wonderful to have you all here. So, while I'm blustering, there is a new case I'm considering covering. And Kevin, I probably will do a video on that. Kevin asks if I saw the sentencing on the mom influencer. That's the Ruby Frankie and Jody Hildebrand. And I'm usually not the first to cover something. Everyone's already covered this, but I do have thoughts on that, and it's different, I think, than some people's thoughts. And so I'll probably do a video on that soon. No guarantees, but there is a new case I'm considering covering, and it's I don't know how many of you are familiar with it, but Grant Cardone, the I don't know, real estate guru, sales guru, purported fraudster, is suing the former CEO of T-Mobile, John Legere, for defamation. And it's a Florida state court case. So, my relationship with state court, there's no guarantee that I cover it wall to wall, the entire lawsuit. But because of recent changes in Florida state law, I'm thinking this could actually be a real interesting one to cover because, as you know, I'm not a politics channel. I'm not a politics channel, but I'm well, first and foremost, so far legal, but also finance. And this Grant Cardone case, like I said, even though I'm not a politics channel, it has some interesting questions because with Ron DeSantis waging war on all things woke, he's managed to push through some changes into defamation laws that I think could be unconstitutional. So this is a case I'm thinking there's actually a pretty good chance Ron DeSantis wins, or not, sorry, because of Ron DeSantis, there's a good chance Grant Cardone would win in Florida state court. And then you appeal it all the way up through the Florida Supreme Court. And then after that, you appeal it to the federal courts. And, you know, with that, it could be overturned. So I'm thinking that could be an interesting case to follow. Let me know your opinions on it. You know, it's got finance implications as well. So, you know, ostensibly, I'm going to start doing finance stuff eventually. We'll see. Good to see you, Barely Legal Briefs. But with that said, that's enough bluster. Let's jump into the docket. And as I mentioned, we are starting today with Braun versus Day. That's Janet and Lauren the Mortician versus the Girlies. The Girlies, of course, being Bekah Day, the Do We Know Them podcast, Jesse Smiles and Lily Marston, and Caffinated Kitti. And frankly, I'm surprised there aren't a few others that, yeah, we'll leave it at that. And this has, as you know, been a mess. And in my, you know, history of being not first, but getting to things eventually, we're a little behind, but I have been sick. So yeah, that's the thing is, Linux guy, Jamie Grayson is the one I was thinking of, the child safety guy. But they've taken down his TikTok channel. They've falsely copyright struck him, but I don't think they're suing him. And same with Cece Suarez. They've done copyright strikes, but they're not suing her. So it's weird. But yeah, so last time we were here in Braun versus Day, we looked at the judge basically said, hey, since this is a diversity case, because you're bringing state law claims in federal court, therefore you need complete diversity. No one on the plaintiff side of the case can be a resident domiciled in the same state as any of the defendants. And there has to be $75,000 or more at controversy. And Janet, well, her attorney, Benjamin Lockyer, they're both, from what I've seen, terrible attorneys. And they basically tried to base the Janet's domicile as, well, yeah, she's a part-time resident of Illinois. And the court on its own came back and said, yeah, about that. That's not good enough. You need to provide us with actual information, her actual domicile. And based on Ian Runkle of the Bailey, so subscribe to Runkle of the Bailey, Ian's great, found some legal shenanigans in California state courts, including a divorce, but by someone with the same name as Jeanette Braun. Turns out there are at least 2 Jeanette Brauns in the world. Imagine that. So we were thinking it might have been in California. Turns out she's in South Carolina, and it's still a mess. I'm still thinking this isn't going to be good enough. It might survive for a little bit. I still think this case itself is going to be thrown out. And if they want to continue, they'll have to file it in some other state. And I have theories on why it was filed in Illinois, but I don't fully understand why it was filed in Illinois. My theory, of course, is that Janet and her lawyer, Benjamin Lockyer, were law school classmates, and so she's getting a real good deal. And Benjamin Lockyer is in Illinois, therefore, let's file in Illinois, as opposed to South Carolina. But that said, let's take a peek at the documents. And in this one, we're going to take a peek at, there's a motion by Janet about sealing the returns of service. So basically, you know, that this is actually decent of them if they had done it right, but so as not to dox people, especially Caffinated Kitti, whose name isn't public. And then after that, we will not look at the summons returns because, frankly, we don't need to, other than to point out that despite it being sealed, they left Caffinated Kitti's name in one spot before fixing it, but we don't need to look at that. And then we'll take a look at the supplement to jurisdiction. And then we will take a look at the motion by the defendants. It's an unopposed motion asking for an extension of time to file a responsive pleading. It was granted. Spoiler alert. So that's what we'll take a look at in that order in this case. So as I mentioned, first, we're looking at plaintiff's motion to file returns of service and jurisdictional supplement under seal. And it's pretty straightforward. Plaintiffs Jeanette Braun, Janet, Braun IP Law, and Lauren Propson, Lauren the Mortician, collectively plaintiffs, present their motion to file returns of service and their jurisdictional supplement under seal and in support state as follows. On December 15th, 2023, the plaintiffs filed this action against the defendants for defamation, false light, and other related counts. The defendants are all social media influencers with hundreds of thousands of followers collectively. Due to this, a large amount of public attention has been brought upon this lawsuit. On January 17th, defendant Marston was personally served at her residence in California. On January 17th, defendant Vasquez was served at her residence in Georgia by leaving a copy of the summons and the complaint with a person of age. So generally, you have to serve the person, but there are methods of substitute service where you can serve a person of legal age who is a resident of their household and say, here you go, this is for defendant Vasquez, and that can work. And then on January 20th, defendant KC, Caffinated Kitti, was personally served at her residence in Georgia. And on January 20th, 2024, defendant Day was personally served at her residence in Missouri. Although there is a presumption in favor of making returns of service and names open to the public, the plaintiffs seek to file the returns of service and portions of their jurisdictional supplement under seal to protect the privacy of the parties and their families from harassment. It is well established that parties to a litigation do not have an expectation of privacy. That's Citizens First National Bank of Princeton versus Cincinnati Insurance Company, 7th Circuit, 1999, which says, the parties to a lawsuit are not the only people who have a legitimate interest in the record compiled in a legal proceeding. Due to this, the records that affect the disposition of federal litigation are presumptively open to public view. That's in respect, 7th Circuit, 2010. However, the 7th Circuit has affirmed district court rulings to keep records sealed to protect the property and privacy interests of the parties. That's Melton versus Pavilion Behavior Health Systems, Central District of Illinois, 2020, which says a court should permit the sealing of documents only if there is good cause to do so. That is, the property and privacy interests of the movement outweigh the interests of the public in full transparency of the judiciary. And that was affirmed to protect the privacy of the parties from harassment. Plaintiffs seek consent from this court to file its returns of service and portions of their supplemental jurisdictional statement under seal. Due to the large amount of public attention in this matter, the plaintiffs seek to seal the parties' addresses and the name of defendant KC to prevent harassment. The parties' addresses and personal information are not central or relevant to any counts in the complaint. For these reasons, plaintiffs respectfully request that the court grant plaintiff's motion to file portions of the defendant's returns of service under seal, grant plaintiff's motion to file portions of their supplemental jurisdictional statement under seal, and for any other relief this court deems just and necessary. Respectfully submitted, signed Benjamin C.R. Lockyer. So that's actually good. We want them to have privacy. The defendants were dragged into court by these jerks. They don't deserve to be doxxed for it. And Taragi, in theory, this isn't Janet. That's Benjamin Lockyer getting all these grammatical errors and typos that I'm trying to convey through speech. But it's possible that Janet had a hand in preparing the documents. Who knows? If she did, though, that could be a conflict of interest, because if she's making these, if she has any hand in making these documents, well, then that would be her representing her co-plaintiff, and that could be a conflict of interest, and that could be malpractice. That's just my thoughts, but we'll see. But either way, you'll remember way back when we did, well, not when we did the complaint. Either way, you'll remember when I read the complaint, I had questions about jurisdiction. And then when the judge brought up his questions about jurisdiction, I said, hey, the correct procedure wouldn't have been to be vague in the complaint. It would have been file the complaint and file a request to seal. And Ian Runkle said the same thing, and Matt Katster said the same thing, and pretty much everyone covering the case said the same thing. Well, they finally got the message. File it under seal. Request to seal it. So we applaud him, Mr. Lockyer and Janet, for finally doing this, but we shouldn't congratulate them too much, because this is something they should have done right out the gate. It's just terrible. And the thing is, Bad Scooter, so by filing frivolous lawsuits and writing crazy cease and desist orders, that's not necessarily malpractice. It's, I'd say, unethical, but malpractice is for her clients. And so if she's doing nutty stuff at the behest of her clients, now let's say Bunny XO didn't tell her to file these copyright claims against Cece Suarez, then it could be malpractice. But let's say Bunny XO is lying and that she actually did or had a standing order with Janet to do it. And it's, CC Suarez, the Girlies, they don't have a malpractice cause of action against Janet because she's not their attorney. They, that they can just seek to recover costs. But either way, and Kevin, it very well could be. Lots of sole practitioners will either have their office in some sort of co-working space, but lots of attorneys, like here in Salt Lake, they're right across from the old federal courthouse, which is now the bankruptcy court. So right there on Main Street, there's the Boston and Newhouse buildings. They're kind of mirrored classical towers, real neat. And there's an entire floor, I believe, taken up by criminal defense attorneys, and they're all sole practitioners. That it's just a shared office space for attorneys, and they're, splitting the cost, but they're all independent. So it might not be that Mr. Lockyer is in a WeWork space. It could be something like that, because office sharing among attorneys who are not part of the same firm is fairly common. And as long as you're not branding them as your partner or your associate, or, it's fine. But next up, we have the supplemental jurisdictional statement. This is what we really want to see today from them, because this is why I still think it's getting dismissed. But it might take a little work from the Girlies' attorney to make it happen. So, pursuant to this court's January 17th, 2024 docket order, plaintiffs Jeanette Braun, Janet, Braun IP Law, and Lauren Propson, Lauren the Mortician, allege as follows. Plaintiff Jeanette Braun and Braun IP Law, LLC. Plaintiff Jeanette Braun is a citizen and resident of Illinois. So, remember in the complaint, she said she's a part-time resident of Illinois. Now she's a citizen and resident. So she's saying she's domiciled. And barely legal briefs, I believe it was an ethical violation, the calls to emergency services. I also believe it was very likely criminal. So there's that. But plaintiff is also licensed attorney, not a licensed attorney. She's just licensed attorney in Illinois, where she operates Braun IP Law, LLC, a law firm organized under the laws of the state of Illinois with a contact address of a UPS store, which, lots of LLCs do that. If that's the mailing address, and you're going to need a mailing address in the state where you organize your LLC. So, yeah. Plaintiff Braun Law has its office and principal place of business in Northbrook, Illinois, engages in Illinois-based law firms, and contributes to local bar association and community events. Plaintiff Jeanette Braun, despite maintaining seasonal residency in South Carolina, is domiciled in Illinois, where she has substantial professional and personal connections, including a residence in Cook County. Her substantial business operations, professional licensure, and active participation in the Illinois legal community are centered in Illinois. While plaintiff Jeanette Braun does own property and spends part of the year in South Carolina, her primary and long-standing economic, familial, and professional ties remain in Illinois, evidenced by her Illinois-based medical care providers, accountants, and legal and business advisors. Plaintiff Braun's participation in community and professional activities, as well as her connections to clients, employees, and colleagues, primarily relate to and impact the Illinois area where her reputation and business are most established. And that's it. Linux guy. Her doctor and accountant are there? Yowzers. You know what I don't see her mentioning? I don't see her mentioning where her cars are registered, where her driver's license was issued, where she votes. Those are the biggest things I'm looking for. So if I'm the Girlies attorney, I'm probably asking for immediate discovery of these items, because these could be dispositive immediately. And I want to know. I want to know. And I'm also asking, so you still own a residence in Illinois? Is it leased out? Is it available for you to live in without notice? If it's rented out, if you've got at least, how can that count towards where you're domiciled? So these are things I want to know if I'm representing the Girlies. And that's it. That's exactly what it looks like to me. She seems to be going out of her way to say, well, look, don't look behind the curtain. You know, the Wizard of Oz commands you, do not look behind the curtain. Just, you know, look at the silly monkey. To mix media, you know, the Wizard of Oz and South Park, but you know, the South Park, it is Johnny Cochran. Look at the silly monkey, you know, part of the Chewbacca defense. That's it. Where's she taxed? Not the LLC. Where is Janet taxed? Which state? Well, I mean, she's going to pay the state income tax where the income is earned, presumably. But yeah, it's I don't buy it. So Jersey's Nana, good to see you, and Pat's Cats. So why? This begs the question: why is she fighting so hard to keep this in Illinois? Because Illinois has a SLAPP law. It's not a particularly robust SLAPP law. SLAPP, of course, being strategic litigation against public participation, whereby you file a special motion to dismiss or special motion to strike. It's a short circuit mechanism right at the start of the case. If you're saying, hey, look, this is free speech, you can't sue me over it, and get rid of it right out of the gate and probably get attorney's fees out of it. Well, Illinois does have a weak SLAPP law. From what I saw, South Carolina doesn't have one. Florida, I don't think has one. And as I mentioned at the beginning, talking about Grant Cardone, Florida has new weird defamation laws. So wait. We'll get to Florida. This would say Florida doesn't have jurisdiction, but there are allegations that it might. And so we know why they're not suing in California, which is where Lily Marston is. Do we know them? Because California has a very strong SLAPP law. Georgia, I can't remember. And that's where two defendants live, Jesse and Caffinated Kitti. Missouri, I can't remember. But either way, moving on. Plaintiff Lauren Propson is a citizen and resident of the state of Wisconsin. Now, Lauren Propson, Lauren the Mortician. So, and that's what I'm thinking, Victor Mann. She doesn't want to hire someone in South Carolina. Her law school classmate is in Illinois, willing to do it either on contingency, low bono, pro bono, whatever, favor for a law school friend. I don't know. That's what I think it is, though. That's what I think it is. So, and Kevin, it was never claimed as California in previous filings. We speculated that it might be California. But with Lauren the Mortician, she's claiming the state of Wisconsin. Now, I'm told by you guys, she actually lives in Florida. So if she actually lives in Florida, well, they might have been able to bring this case in Florida and test out those wacky new laws that I don't believe are actually constitutional. And for those of you in the know, the dad, I believe, whose mortician's license he works under, is in Wisconsin, and she actually lives in Florida, or is it the other way around? Either way, doesn't matter, because they're not trying to get it in Lauren the Mortician's jurisdiction. They're trying to get it into one of Janet's. But either way. And as far as this goes, if I seek discovery on this, it's really just for candor to the court purposes. Show, hey, look, they're lying. They're putting false information in their filings. Whereas, since they're not trying to get the case in Wisconsin, and there's no one else that lives in Wisconsin to get rid of the diversity jurisdiction, it doesn't really matter. So, but defendant Rebecca Day Box is a citizen and resident of the state of Missouri. Defendant Caffinated Kitti, the operator and owner of the social media account Caffinated Kitti, is a citizen and resident of the state of Georgia. Defendant Jessica Vasquez is a citizen and resident of the state of Georgia. And defendant Lily Marston is a citizen and resident of the state of California. Respectfully submitted, signed Benjamin Lockyer. So, like I said, if I'm the Girlies attorney, I am doing immediate discovery requests. I'm letting the court know, hey, I do not believe them. I need more information because I contest this. And you're just in time, Imugi, for our second topic. Well, not quite. You're a little early for our second topic. So, yeah. And it was a dumb name, so I changed it. I don't know who you used to be, but it's a minimum of $75,000, I believe. Not that it matters. You're not going to claim exactly $75,000 unless it's a contract. You're usually going to say it's at least $75,000, but please give us more. So, yeah. But lastly, for this topic, we have the unopposed motion for extension of time to respond to complaint. Now comes the defendant's by and through its undersigned counsel and files this unopposed motion for extension of time for defendants to respond to the complaint. In support of its motion, defendants state as follows. Plaintiffs Jeanette Braun, Braun IP Law, and Lauren Probson filed their complaint in this court on December 15th, 2023. Defendant Bekah Day was served with a copy of the summons and complaint in this lawsuit on January 20th, and thus her responsive pleading is due on or before February 10th, 2024. So that's almost 2 weeks ago. Defendant KC, the owner and operator of the online social media account Caffinated Kitti, was served with a copy of the summons and complaint in this lawsuit on January 20th, 2024, and thus her responsive pleading date is due on or before February 10th, 2024. Lily Marston was served with a copy of the summons and complaint in this lawsuit on January 17th, and thus her responsive pleading is due on or before February 7th. And same with Jessica Vasquez. Defendants represent that this request for extension is made in faith in order to adequately respond to the allegations in plaintiff's complaint and not for purposes of delay. Defendants have conferred in good faith with plaintiff's counsel regarding this motion for extension of time, and plaintiffs agree to this motion for extension of time and do not oppose the requested relief. No prior extensions have been requested or granted in this matter for any reason. Wherefore, defendants respectfully request that this court enter an order extending the time for all defendants to file an answer or other responsive pleading up and including February 29th, 2024. So you may remember last week when, you may not remember if you only come for this case, but when we were discussing the delete laws case, DeCastro versus LVMPD, because Michael Mee, his attorney, who, despite having represented him in the criminal case for at least 6 months, knowing the subject matter, and from the date he made his appearance, he had 16 days to file his new opposition to the motion to dismiss / motion for summary judgment. I need more time. I'm brand new to this case. And you may remember I said that, number one, I had my doubts that he actually needed more time. I was not completely in favor of new time, but I also said I'm not surprised the court granted it, because when I'm hired at the start of a case, criminal, civil, whatever, lawyers tend to get hired right before the answer is due. And so whether I have 1 day or 2 weeks or whatever, 3 weeks, first thing I'm going to do if I need more time is I'm going to ask for more time, especially if I'm hired with the deadline looming. And so, and right out the gate, it's generally going to be approved. Whereas, like I said, delete laws, well, he'd had lots of delays. Around Christmas, I'm so busy with my other lawsuits, I can't possibly respond. And besides, I don't even know which one to respond to because it's pled in the alternative. And even though I plead things in the alternative, I don't understand pleading in the alternative. So I need guidance from the court on what to even respond to. So he'd already had an extension of time, and then Michael Mee asked for an extension of time, and I was not particularly happy about it. But in this case, you'll see, hey, no prior extensions have been requested or granted in this matter for any reason. So it's unopposed, which, to be fair, Michael Mee's request in DeCastro was also unopposed. Craig Anderson was, yeah, whatever, do your thing. It'll be nice to read something that's not gibberish from ChatGPT. Not that it wasn't gibberish, but so yeah, This makes sense, especially since in theory, that there was stuff going on between the complaint being filed, well, it was around the time the summons were issued, but the whole jurisdiction kerfuffle, that's kind of, that throws a wrench into even responding. So that's another good reason to ask for an extension. So it makes sense. It makes sense. It's unopposed, and it was granted. Spoiler alert. And so, let's see. On February 13th, we have the order of the court minute entry before the Honorable Mary M. Rowland. The court has reviewed defendant's unopposed motion for extension of time. Defendant's motion is granted. Defendants shall answer or file a responsive pleading by February 29th, 2024. The deadline of the 28th for parties to file a joint initial status report is reset to March 21st. So, yeah, basically the attorney whose name I didn't look at because I didn't, Amy Doig and Brandon Whitcow. So Brandon Whitcow is the excellent California attorney the girlies mentioned in their video or GoFundMe. Amy Doig, I believe, is probably their local counsel. So basically, some jurisdictions of federal court, you can practice wherever you're located. You may have to just file for admission. You may have to file for permission to practice pro hoc vice, but some you have to ask for permission to practice pro hoc vice, and you need a local counsel who basically files for you, is on the hook if you screw up, but doesn't actually really do anything. So I'm assuming that's what Amy is. Brandon Whitcow is the attorney. So yeah, but they, as we saw, they asked for February 29th. They got February 29th. So we expect a responsive pleading in 6 days' time, within 6 days' time. So by next Thursday, we'll have an update. So, and I'm looking forward to it. With that said, timestamp 43 minutes. Remind me, because we are moving on to Scofield versus Guillard, the TikTok psychic case. And this one, we are not going to fully catch up today, but we're going to make a start. And you may remember, scrolling down in the docket, and Kevin, I'm trying to keep it a fun Friday, but not a 4-hour Friday. Hopefully you guys can go watch Artie or Law and Lumber or one of the hundreds of other people that stream on Friday nights. That's why I try to stream a little earlier than I naturally would like to, just so that, yeah. So last time we were here, we covered docket number 63, and it was the amended motion for partial summary judgment. So remember, well, let's back up. So Professor Scofield filed a complaint. It went into default, was taken out of default. We're going back to the beginning. Ashley Guillard, the TikTok psychic, answered, didn't bring a motion to dismiss. She answered, and now she's complaining of it. not being able to do a motion to dismiss, basically. But, we had the kerfuffle, we had counter complaints, they were dismissed. We had a motion for summary judgment saying, yeah, she didn't even respond to discovery. She didn't give us the request for admission. So, court, you've got to take them as admitted. And she said, well, I didn't receive the discovery request because I was in New York, even though they were emailed to her. So she should have got them even in New York because email works in New York. Well, and, they didn't even file for that until 2 months after they were due. But the court still gave her another bite at the apple, Ashley Guillard. So we had on January 12th the amended motion for summary judgment. And that was basically Professor Scofield saying, yeah, so we got her discovery responses, we got her request for admissions, and we still deserve summary judgment. There's still no actual question of just of fact, no disputed question of fact. So we deserve partial summary judgment. We win, she loses. We just need to go to trial to figure out how much we win. Well, you may remember, I know it was a month ago. I'm behind. I've been sick. But you may remember that very same day as I was covering it, I mentioned that docket number 64 was filed, but we didn't know what it was yet because there's a delay in Idaho with Pacer. Paul Berry, good to see you. Missed you on the live last week. I know you watched it later. We're on to topic number 2. We're just getting started on Scofield versus Guillard. We've already finished the Girlies. So, yeah. But yeah, so this had popped up. I didn't know what it was. I think it was titled Motion for Leave, and that's all. Had no idea what it was. A day or two later, we knew what it was, and we're going to cover it now. And so it ended up being a motion for leave to file an amended complaint. So they've already got their motion for summary judgment, but now they want an amended complaint, Professor Scofield, and because they want to add punitive damages to their prayer for relief. And they have all these attachments. So Exhibit A is, well, it doesn't tell us what they are, but either way, we've got all these attachments. We're not going to look at all of them, but after that, I don't think we're going to do these today. There'll be another video, but we have to get fully caught up. The response to the motion for partial summary judgment by Ashley Guillard. We have the response by Ashley as well to the motion for leave to file an amended complaint. I think these are basically the same document, but we'll see when we actually do them in a future video. And then we have the replies from Professor Scofield. But like I said, those are all for another video. Today we're focusing on 64, the motion for leave to file an amended complaint. And so this is the motion itself. Like I said, I don't like jurisdictions that split the motion into one document and then the memorandum in support into a different document, but that's what we have here. But either way, this is the motion for leave to amend complaint to add punitive damages. So plaintiff Bekah Scofield, by and through her attorneys of record, Stoll Reeves LLP, submits this motion for leave to amend complaint to add punitive damages and supporting factual allegations against defendant Ashley Guillard pursuant to Idaho Code Section 6-1604 and this court's scheduling order. Attached hereto as Exhibit A is the proposed amended complaint. Attached hereto as Exhibit B is a red line comparing the proposed amended complaint against the complaint. So that's what we're going to look at, is actually Exhibit B, because we've already read the amended complaint. That was our last video. Well, no, sorry. We did the amended complaint quite a while ago. The motion for summary judgment was last video. Sorry. But either way, we've already looked at Exhibit A because we've already done a video on the amended complaint. That's like a year ago. We don't need to do that. So what we're going to do is we're going to look at Exhibit B and the red line comparing the proposed amended complaint against the complaint. So basically, we're going to look at what was added, the changes, and they're going to be in red. Makes it easy for us and the court. And then we'll read the actual memorandum in support of the motion telling us why, even though there's an outstanding motion for summary judgment, why should the court grant this motion? So that's what we'll do. So this motion is supported by the memorandum filed in support, the declaration of Wendy J. Olson filed in support with exhibits thereto, and all pleadings and papers on file in this matter. Dated January 12th, 2024, Stoll Reeves LLP, signed Wendy J. Olson. So, like I said, I already have it open, but this is Exhibit A, which is the amended complaint. We don't need to look at that. We are going to skip to Exhibit B, which is also the amended complaint and demand for jury trial, but we are going to skip most of the way to the bottom and look for the red lines. Like I said, it's mostly the same because, frankly, it would be unfair to bring massive changes. But you'll see why they did this. I'm not going to explain it yet, but you'll see why they did this, why it makes sense. It makes it easier for the court. So this is we're still in the history, the factual allegations section, but and we've got it renumbered. So let's just start on number 31, paragraph 31, which is existing, but rather than change her conduct, Guillard made a TikTok showing the cease and desist letter, acknowledging she received it, and explaining that if Professor through counsel believed that Guillard was making false statements, counsel would need to file actual legal documents in a federal court, asking me to remove it. A judge will then determine if I need to remove it. And, well, they did file in federal court, so yeah, you asked for it. But first red line, they split paragraph 31 into two paragraphs. So first red line is just the renumbering. And so also after receiving the cease and desist letter, Guillard on December 18th and 19th, 2022, posted more than 20 new TikTok videos falsely stating that Professor Scofield was involved with KG and that Professor Scofield's motive for the murders was to keep KG from making their relationship public. So now paragraph 33 is the first real change. And first things first, you'll notice the tone shift. It's not plaintiff did this or defendant did this. It's Guillard became aware that on or about December 27th, 2022, the Moscow Police Department issued a press release related to the murders stating, at this time in the investigation, detectives do not believe the female associate professor and chair of the history department suing a TikTok user for defamation is involved in this crime. And then Guillard continued to state Professor Scofield was involved in the murders even after becoming aware of the press release. So why did they add that? And why is it so significant? Why couldn't they have added this before? It's because this is something they had confirmed through discovery. So it's not Guillard should have been aware. It's, hey, she has admitted that on or about December 27th, she was aware. She has admitted through discovery, through the request for admissions, she admitted that she knew that the Moscow Police Department had already said, yeah, it wasn't Professor Scofield. So this shows that she had actual knowledge on December 27th, but the renumbered paragraph 35, Guillard has continued to publish false statements about Professor Scofield on TikTok, despite having a basis for making the statements, and despite being notified numerous times that her statements were false. And this isn't in the text, but despite acknowledging that she was aware that the Moscow Police Department had issued that statement. And then all this is in red now. On or about February 8th, 2023, Guillard published a YouTube video in which she falsely stated that Professor Scofield has photographs, videos, and messages from the night of the murder and during the murder on a collaborative book literature app she used to collaborate with the people she had help her plan and execute the murders. In that February 8th, 2023 YouTube video, Guillard also falsely described how Professor Scofield first mentored, then began an affair with one of the students. On or about June 9th, 2023, Guillard participated in an interview posted on the YouTube program Nerd Report, in which she said that the arrest of Brian Kohberger did not change her mind about Professor Scofield's involvement in the murders. She also falsely stated that Professor Scofield contacted Kohberger on a whim on the day of the murders. And on or about October 14th, 2023, Guillard posted yet another YouTube video stating that Professor Scofield was responsible for the murders. Guillard has admitted that she has no physical evidence or written information supporting her false statements that Professor Scofield was involved in the murders or had an affair with one of the victims, and she has admitted that no person provided her with any such information orally. So once again, some of this, like the new videos they're reporting, like the Nerd Report, it's possible that they only found out about these videos through discovery. And once they had it through discovery, now this is just me speculating that they only through discovery. And so, you know, the one on Guillard's YouTube channel, it might have been taken down. Like it might not have been public for the attorneys to have seen. But if they found out about it through discovery, hey, it's now in the complaint. And especially the Nerd Report one. But, you know, they have her admission that she has no actual evidence other than her spiritual acuity. But she has admitted through discovery, requests for admissions, that she has no actual evidence. no physical evidence or written information. No one provided her any such information orally. No ghost whisperers. Well, they don't count. No Suwants. No John Harrington, to keep with the South Park references. So, hey, that's why they are requesting to add this. So, and then finishing off the factual allegations, Professor Scofield's never met Guillard, and Guillard's TikToks have damaged Professor Scofield's reputation. So, no changes in the first claim for relief, other than renumbered paragraphs, of course. Shouldn't be any changes in the second. No changes in the attorney's fees, but under prayer for relief, as mentioned, we have the added request for punitive damages as provided under Idaho Code Section 6-1604. Let's actually Google that. And Title 6, Actions in Particular Cases, Chapter 16, Periodic Payment of Judgments, Limitation in Certain Tortages and Liabilities. 6-1604, Limitation on Punitive Damages. And despite this being in federal court, this is, of course, brought on state law claims. Therefore, Idaho state law on punitive damages controls. I was watching the Sovereign Citizen video the other day. Can't remember which one it was, but they brought up Tompkins Erie Railroad versus Tompkins, which they got completely wrong. But basically, that's a Supreme Court case that basically says, yeah, there is no federal common law for state law claims. You've got to use the state common law. We don't do that. So this just reminded me of it because, like I said, you've got to look to the state law, even though it's in federal court. So, 1. In any action seeking recovery of punitive damages, the claimant must prove by clear and convincing evidence oppressive, fraudulent, malicious, or outrageous conduct by the party against whom the claim for punitive damages is asserted. So you can't just say, hey, I was damaged. First, you've got to prove it by clear and convincing evidence. So that's a higher standard than why am I blanking? I really am a lawyer, just one with a terrible memory sometimes with brain farts. But basically, you look at it, it's maybe 75% sure. It's not quite. My brain is not functioning today. Not quite reasonable doubt. But so preponderance. Thank you, Linux guy. It was just a brain fart. But so preponderance, of course, is like anything above 50%. Reasonable suspicion, probable cause, those are much lower standards. Clear and convincing is quite a high standard. That's lots of stuff in estate planning has to be proved by clear and convincing evidence. So And that's because, you're dealing with the wishes of a dead person. So you've got to have pretty good evidence, because, the dead person can't come back and say, no, no, you fools, this is what I wanted. So Brandon, why would you want to do adulting on a Friday night? Why would you do that to yourself? Other than, like I said, Friday night is a busy night and stuff. But yeah, thanks for stopping in, though. But yeah, so in order to get punitives by clear and convincing evidence, you need to prove that you were damaged by oppressive, fraudulent, malicious, or outrageous conduct by the party. And so they think now that they're able to show that this was oppressive, fraudulent, malicious, or outrageous conduct, which I agree with them. To me, it would be, but you might have to look at how, what constitutes outrageous or oppressive or fraudulent or whatever. But paragraph 2, in all civil actions in which punitive damages are permitted, no claim for damages shall be filed containing a prayer for relief seeking punitive damages. However, a party may, pursuant to a pretrial motion and after hearing before the court, amend the pleadings to include a prayer for relief seeking punitive damages. The court shall allow the motion to amend the pleading if, after weighing the evidence presented, the court concludes that the moving party has established at such hearing a reasonable likelihood of proving facts at trial sufficient to support an award of punitive damages. A prayer for relief added pursuant to this section shall not be barred by lapse of time under any applicable limitation on the time in which an action may be brought or claim asserted, if the time prescribed or limited had not expired when the original pleading was filed. Paragraph 3, no judgment for punitive damages shall exceed the greater of $250,000 or an amount which is 3 times the compensatory damages contained in such judgment. If a case is tried to a jury, the jury shall not be informed of this limitation. The limitations on non-economic damages contained in this section are not applicable to punitive damages. So it's only for, Paragraph 4, nothing in this section is intended to change the rules of evidence used by the trier of fact in finding punitive damages. So basically, paragraph 2 tells us why they are amending the complaint now. It's because under Idaho law, even though this is in federal court, Idaho law says you can't ask for punitive damages right out of the gate. You cannot, by law, ask for punitive damages in your initial complaint. You have to seek leave to amend and add the request for punitive damages at the appropriate time. So that's what they've done. And paragraph 3 limits it to it shall not exceed the greater of $250,000 or an amount which is 3 times the compensatory damages contained in such judgment. So you may remember in the Depp versus Heard trial, there was a Virginia law on punitive damages. And so even though Johnny Depp was awarded around $10 million in compensatory damages, that's to make him whole, and $5 million in punitive damages, that's to punish Amber Heard for her outrageous conduct. There was the Virginia state law that limited it to $250,000, $350,000 of punitive damages. But the jury didn't know that. It was just reduced after. So same thing here. Same thing here. But from my reading of this, let's say Professor Scofield gets the full $2 million of compensatory damages she has requested. By my reading, it's not $250,000 here. It could be up to $6 million of punitive damages, because it's the greater of $250,000 or 3 times the compensatory damages. So if she's awarded $2 million in compensatory, she could get $6 million of punitive. If she's $75,000, even though $75,000 is the jurisdictional amount, the jury could award her $50,000 and that wouldn't destroy jurisdiction. But, if she's awarded $50,000, just for easy math, $50,000 of compensatory damages, she'd be limited to $150,000 of punitive. So that's my reading of it. I'm not an Idaho state lawyer, so I don't have experience with this particular law. But that being said, let's move on. And this is the memorandum in support of the motion for leave to amend complaint to add punitive damages. Like I mentioned, I don't like how they do this in Idaho and some other jurisdictions, but like I'm looking at you, Massachusetts, do it like Nevada does, put it all in one document. Either way, we're looking at the memorandum in support, telling us why the court should allow these changes, the amendments. Professor Scofield requests leave of the court file her proposed amended complaint to add a prayer for punitive damages with supporting factual allegations. So in addition to, like I said, the redlined additions, lots of it was stuff they found out through discovery, but it's also supporting factual allegations for, why they think this was oppressive, fraudulent, malicious, or outrageous conduct. It bolsters that claim. It bolsters their claim for punitive damages. So this court's scheduling order set a January 12th, 2024 deadline for filing such a motion for leave to amend. And remember, looking at the docket, this was filed on January 12th. We didn't know what it was yet on January 12th. Thus, this motion is timely. Defendant Ashley Guillard's responses to Professor Scofield's request for admission show that she has no facts to support her extreme and outrageous assertions that Professor Scofield had an affair with a student and then planned, initiated, ordered, and executed the murder of the 4 University of Idaho students. So notice, they're using the same language as was in the law that we just read. Extreme and outrageous assertions. Ms. Guillard also has continued to make and participate in YouTube videos repeating these false statements. Punitive damages are appropriate. Factual background. In November 2022, 4 students at the University of Idaho were murdered at a home near campus. And footnote 1 is going to say we're using their initials. It's almost like it's the same footnote as every prior pleading we've read, so I knew what it would say. Ms. Guillard, a resident of Texas, took this tragedy as an opportunity to post sensationalist content online, attract clicks, and make money. Declaration of Wendy J. Olson, is the citation, blah, blah, blah. According to Ms. Guillard, she used her spiritual practice, psychic abilities, and metaphysical tools, including tarot cards, to post over 100 TikTok videos of her supposed findings concerning the murders near the university. Ms. Guillard's purported findings, which she posted on the social media website TikTok, went like this. Professor Scofield had a same-sex affair with one of the victims and then planned, initiated, ordered, and executed the murder of the 4 University of Idaho students. Ms. Guillard has admitted that she made these sensational statements, although now she claims she was just relaying the results of a tarot card reading, and she has admitted that these statements were not based on any facts. Ms. Guillard has also admitted that her false statements are based on her spiritual research, intuition, instincts, and investigative skills, and that she currently has no physical evidence, written information, or oral information from another human being that support her false statement. She states that she hopes to find facts to support her position through discovery in this case, but she has none, and discovery is closed. She made those same statements to this court in a hearing on Professor Scofield's motion to dismiss her counterclaims. The University of Idaho records that any of the 4 students or the student Ms. Guillard alleged that Professor Scofield hired to commit the murders took a class from Professor Scofield or communicated with her. Ms. Guillard continued to make false statements that Professor Scofield had a same-sex affair with one of the victims and planned, initiated, ordered, and executed the murders even after receiving cease and desist letters from Professor Scofield in December of 2022, and even after she knew that the Moscow Police Department had issued a press release stating that it did not believe Professor Scofield was involved in the murders. And you'll notice it no longer says, in previous statements of the facts, it said, even after the Moscow Police Department issued a press release. Now it says, even after she knew that the press release was issued. See how it's changing since discovery was completed? It's not just the amended complaint. The language in motions is changing as well. And Ms. Guillard has continued to make these same false statements over and over and over again in the 13 months since Professor Scofield filed this lawsuit. For example, in a YouTube video posted on February 8th, 2023, Ms. Guillard provides a detailed narrative of her sensational story about Professor Scofield and claims that Professor Scofield has photographs, videos, and messages from the night of the murder and during the murder on a collaborative book literature app she used to collaborate with the people she had help her plan and execute the murders. In an interview for the online program Nerd Report, posted on June 9th, 2023, Ms. Guillard states that she still asserts Professor Scofield was involved in the murders even after learning of Brian Kohberger's arrest, and then went on to describe how on the day of the murder, Professor Scofield connected with Kohberger on a whim and used him as a tool to see what was going on. In that same interview, she explained how she gained traction for her claims about unsolved murders by posting about them on social media. Most recently, on October 14th, 2024, Ms. Guillard posted a YouTube video in which she discusses this litigation, again states that Professor Scofield murdered 4 people, and states that Professor Scofield would get away with it if it wasn't for her. And this video on YouTube is one of the few Ashley Guillard videos that we have actually covered on this channel. You may remember we did it right around Halloween because, it was posted on October 14th. I didn't find out about it until about 2 weeks later. This is the video where she says, once this litigation's done, she's going to sue Atozy and Markey and everyone else making videos about her. And I said, bring it, bitch. Because you may remember, we brought up the concept of non-mutual collateral estoppel, blah, blah, blah. Basically, issue preclusion saying, hey, once you lose this lawsuit, the issue is closed. So if you go and sue Atozy and Markey and whoever else saying they defamed me by saying I made this up, all we'd have to do is take the results of this lawsuit and say, no, 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 you've already had the chance to defend yourself in court on these claims. And a court has already said you did not have a reasonable basis to make these claims. A court has already said you making these claims was defamation against Professor Scofield. So for people to say you didn't have a basis to make these claims, you made these up, whatever, that issue is precluded. So that's a short circuit right there at the beginning of a lawsuit. Any lawsuit you bring against Atozy, Markey, me, Emily Baker, Mad Catster, whoever. So yeah, we covered this video. But argument, legal standard, punitive damages claims are governed by Idaho Code Section 6-1604. And that's what we just looked at. Section 1604, paragraph 1, provides that in order to recover in italics, punitive damages, plaintiffs must show by clear and convincing evidence, so not preponderance. See, I remembered at that time, even though it's still on my StreamYard's screen, but I really do know what preponderance standard is, even when I have brain farts. But so not preponderance, by clear and convincing evidence, oppressive, fraudulent, malicious, or outrageous conduct by the party against whom the claim for punitive damages is asserted. However, amending the pleadings to seek punitive damages requires a lesser showing. Who have I been following the Tiffany Henyard debacle? I do not know who Tiffany Henyard is, so no, I haven't. If it's a lawsuit, send it to me, and if it amuses me, I'll cover it. So no, notice they say in order to recover, you need to show it by clear and convincing evidence. But to amend the pleading, you have to show a lesser standard. And that is what it said. Switching back, let's see. So the court shall allow the motion to amend the pleading. So not recovery, but to amend and ask for punitive damages. If, after weighing the evidence presented, the court concludes that the moving party has established at such a hearing a reasonable likelihood of proving the facts. So in order to collect, in order to recover punitive damages, it's clear and convincing evidence. In order to be allowed to amend and ask for punitive damages, you have to show that you have a reasonable likelihood of collecting. So reasonable likelihood, to me, I could be wrong, we'll see, they'll probably argue this. to me, is a lower standard than preponderance. It might be preponderance, I don't know. But to me, it's a lower standard, definitely lower than clear and convincing. To me, it's probably the civil litigation equivalent of probable cause. So probable cause is, hey, there's a reasonable likelihood that this happened, but you know that makes the charges stick, but you have to prove it beyond reasonable doubt. So I will look into it, or at least I'll try to remember to look into it. We'll see. But like I said, I haven't heard anything about it. Although I think I've seen, like, I think I saw that there was a politician that physically attacked someone. I don't remember where that was. That's the only thing I can think of that I've seen. But either way, let's stick to this for now. Tiffany Henyard might be a future case. We'll see. But the court shall allow the motion to amend the pleading if, after weighing the evidence presented, the court finds that the moving party has established at such a reason, as in at the hearing, a reasonable likelihood of proving facts at trial sufficient to support an award of punitive damages. So that's what we just looked at on the Idaho website with the law. It's almost like I should just keep reading her argument here instead of switching back and forth, because they'll get to it. Since the plaintiff need only show a reasonable likelihood of establishing its entitlement to punitive damages, a court reviews the evidence in the light most favorable to plaintiffs, with the benefit of all legitimate inferences without assessing credibility. And that's quoting the estate of Kane versus Epley's Inc., District of Idaho, 2017. So it looks like the reasonable likelihood is basically the 12B6 standard. It's, hey, look at the allegations, take them as true, and if they're true, do they, would you be able to collect punitives? They're saying yes here. Now, of course, the jury gets to decide credibility, and they don't have to take it as true. They get to determine credibility and say, yeah, we believe you, or no, we don't. So the question is not whether a plaintiff will succeed at trial on its punitive damage claim, or whether the evidence is uncontroverted. Rather, a claim for punitive damages should be permitted if the plaintiff has shown a reasonable likelihood they could prove by a preponderance of the evidence that the defendant acted oppressively, fraudulently, wantonly, maliciously, or outrageously. And that's Vendelin versus Costco, just Idaho Supreme Court, 2004. So basically, this basically confirms what I said. It's the reasonable likelihood is a lower standard than preponderance, because this is saying, even though it says preponderance in here, it says you've got to allow this if the plaintiff has shown a reasonable likelihood that they could prove by a preponderance of evidence. So it's not, you've got to show by a preponderance of the evidence. It's you've got to show that you'd have a reasonable likelihood of even reaching preponderance standard. But then in order to actually collect, it needs to be clear and convincing. To recover punitive damages, a plaintiff must establish both a sufficiently bad act and a bad state of mind. So this is basically the civil equivalent of mens rea, because remember, in criminal law we have the concept of actus reus and mens rea. So actus reus is the actual crime. It's what did you do to commit the crime. And mens rea is the state of mind. So it's the mental requirement. It's, did you intend, did you intentionally do this? Did you recklessly do this? Did you negligently do this? Because pretty much all crimes say did that, murder is you intentionally killed someone. Whereas manslaughter, the mens rea is lowered, but punishment is also lowered. So manslaughter is, did you negligently kill someone? Negligently is much lower than intentionally. And reckless could be manslaughter or murder, depending, it's weird. Doesn't matter here though. But either way, the bad act here would be the defamation, the statements you made. That is the civil equivalent of the actus reus. And the bad state of mind, that would be the intent, the mens rea, the bad state of mind. So did here, outrageous, well, that's not exactly a state of mind. It's still the action, but it's did you do something outrageous? Did you intend to do something outrageous? So either way, that's Hall versus Farmers Alliance Mutual Insurance Company, Idaho Supreme Court 2008, quoting Myers versus Workman's Auto Insurance, Idaho Supreme Court 2004. The bad act requirement is established by showing that the defendant acted in a manner that was an extreme deviation from reasonable standards of conduct, and that the act was performed by the defendant with an understanding of or disregard for its likely consequences. That's Seiniger Law Office, PA versus National Pacific Insurance Company, Idaho Supreme Court 2008. The bad state of mind requirement is met by proof of an extremely harmful state of mind, which can be characterized as malice, oppression, fraud, or gross negligence. And you'll notice, even though with the murder example, the intent I used, the mens rea levels, I said intentionally, negligently, recklessly. Well, malice is intentionally. In lots of murder statutes, it varies by state. The malice aforethought, that would be the intentional murder, intentional with pre-planning. So malice would be intent. Gross negligence, well, I mentioned negligent as one of the criminal mens rea standards. Gross negligence would be higher than negligence, but it in many states, criminal negligence is higher than civil negligence. As far as intent goes, remember way back when we discussed the Alec Baldwin case, his the Armour's trial started yesterday, I believe. Haven't been covering that, but either way, we discussed in New Mexico the criminal negligence standard, and it was a relatively high standard, but it also for that had a relatively higher punishment than you'd expect for mere negligence. So gross negligence could be a higher standard than mere negligence. In general, the primary purpose behind an award for punitive damages is to deter similar conduct from happening again in the future. That's Walston versus Monumental Life Insurance Company, Idaho Supreme Court, 1996. Professor Scofield has established a reasonable likelihood of proving facts at trial sufficient to support an award of punitive damages. Here, Professor Scofield has established a reasonable likelihood of proving facts at trial sufficient to support an award for punitive damages. Professor Scofield can establish that Ms. Guillard acted oppressively, fraudulently, or outrageously. Professor Scofield can establish that Ms. Guillard committed a bad act with a bad state of mind. Ms. Guillard's TikTok videos, her admissions to the request for admission, and even her more recent YouTube videos, like the one we covered around Halloween, show that Ms. Guillard has accused Professor Scofield of being involved in an extramarital affair with a student at the university at which she teaches and a serial killer, even though technically that would qualify her as a spree killer, but who's counting? Despite repeatedly acknowledging that she has no evidence admissible in any court, and now with facts discovery closed, she will not get any. Ms. Guillard is unrepentant. She persists in making the very same false statements, even after being told repeatedly that her statements are false, and even after the state of Idaho has charged someone else with the murders. Such repeated conduct is indisputably wanton, malicious, and outrageous. If only it were despicable so I could do my Daffy Duck impression. Ms. Guillard's statements made on TikTok after the murders variously asserted, falsely, that Professor Scofield killed the students, was the one to initiate, plan, and hired the supposed hitman, ordered the murder of the 4 University of Idaho students, and broadly claimed that Professor Scofield was involved in the killings. Ms. Guillard also made statements on TikTok after the murders, asserting, falsely, that Professor Scofield was having an affair with KG and ordered the murders to cover that up. Ms. Guillard's statements in the YouTube videos posted after Professor Scofield filed her lawsuit are equally outrageous. In a February 8th, 2023 YouTube video, Ms. Guillard alleged that Professor Scofield has photographs, videos, and messages from the night of the murder and during the murder on a collaborative book literature app she used to collaborate with the people she had to help her plan and execute the murders. Ms. Guillard claims in the video that anyone can get the photographs, video, and messages from Professor Scofield by issuing a subpoena to her. But Ms. Guillard did not even do so in this case. So, this moron, anyone can subpoena this. That's false, by the way. But anyone can subpoena these pictures, but Ashley Guillard, who actually could have issued a subpoena, didn't. She was engaged in discovery, but she didn't. I couldn't have subpoenaed it. Do you know why? Because you only have subpoena power through the courts. And I'm not involved in litigation where this would be relevant. So I can't use the power of a court to compel anyone to give me anything. So even if it's relevant, I can't get it. She could have, but she didn't even attempt to, even though anyone could do it. Anyone. Right there. She claims in a video that anyone can get it. Except her, apparently. I mean, this collaborative literature app presumably isn't a government, so you can't file a public records request. So that's out. No FOIA, no freedom of information. It's how could anyone get it? Pro se's tend to be pretty good at making up laws for some reason. She purports to describe in detail how Professor Scofield first mentored, then began an affair with one of the students, often meeting up with the student when Professor Scofield's husband was out of town. In a June 9th, 2023 interview posted on YouTube, Ms. Guillard said that the arrest of Brian Kohberger did not change her mind about Professor Scofield's involvement in the murders. Instead, she claimed that Professor Scofield contacted Kohberger on a whim on the day of the murders. Unsurprisingly, however, the indictment charging Brian Kohberger does not give any suggestion that any other person was involved. Finally, on October 14th, 2023, Ms. Guillard posted another YouTube video focusing on this litigation and again stating that Bekah was responsible for the murders and saying she's going to sue Atosi and Markey and everyone else. And I said, bring it, bitch. The statements themselves are bad acts. They show an extreme deviation from reasonable standards of conduct because they were not based on any facts to begin with, and because Ms. Guillard continued to make them, even after she was aware of clear facts showing they were false. They were also made by the defendant with disregard for their likely consequences on Professor Scofield. That the statements were made without any factual basis and continued to be made after Ms. Guillard received the cease and desist letters, knew the Moscow Police Department did not believe Professor Scofield was responsible for the murders, and knew that someone else had been arrested with no evidence of connection to Professor Scofield, also proves Ms. Guillard's bad state of mind. Her ongoing statements were made at least with gross negligence. And remember, let's mark our place here. Gross negligence, we need clear and convincing evidence, but the case law says wherever it was, it said, you know, wantonly, maliciously, gross negligence. Either way. Maliciously, gross negligence, a couple others. Either way. That Ms. Guillard has posted internet videos or participated in YouTube interviews in the 13 months after the lawsuit was filed, further spreading her false statements, all while not obtaining a single fact in discovery that supports her allegations, only underscores that she engaged in bad acts with a bad state of mind. Conclusion. The primary purpose of a punitive damages award is to deter similar conduct from happening again in the future. That's from Walston. Ms. Guillard's false statements on TikTok about the University of Idaho murders and Professor Scofield's role in them were designed to gain notoriety and attention for Ms. Guillard. She admitted as much in the June 9th, 2023 Nerd Report interview when she explained how she got traction for her posts on unsolved crimes. So remember, in her opposition to the motion for summary judgment, she said, hey, Professor Scofield says I benefited financially from my TikToks, but she's lying. I didn't make money off of them. But she says here, that's how she got traction. And by getting a bigger following on TikTok, that's how she gets, presumably, her paid dupes for her psychic activities. That's how she gets people to ask her to do tarot readings for them. So Ms. Guillard's conduct is precisely that which punitive damages were designed to address. Professor Scofield has set forth more than sufficient evidence for the court at this stage. So at this stage, not down the line where it's got to be clear and convincing for punitive, but at this stage where it's got to be reasonably probable, reasonable probability of success, I should say. So at this stage, more than sufficient evidence to find that she has a reasonable likelihood of proving facts at trial sufficient to support an award of punitive damages. It's almost like I should just read what her attorneys wrote. Because if I continued and read what they wrote, they said the exact same thing I interjected. If only I had read ahead. It's almost like I know what I'm talking about, even if I have brain farts and don't remember what something is, what a word is, like preponderance. Accordingly, Professor Scofield respectfully requests that this court grant her motion for leave to amend her complaint to add a prayer for relief for punitive damages and additional facts in support thereof. Dated January 12th, 2024, Stoll Reeves, LLP, signed Wendy J. Olson. So, like I mentioned, we're not getting fully caught up. We're just getting partially caught up here today. And we're going to leave it there. Next time we return to this case, which, it might not be the next video because we need to get caught up on DeCastro. We need to do the other case I've mentioned. There's the Grant Cardone, be sure, leave comments, especially you guys on replay crew who can't leave it in the chat, but give me a comment if you want to at least start covering the Cardone versus Leger lawsuit, because that could be fun. But next time we come back to this, we'll take a look at Ashley's responses and the replies to those responses. And no guarantee it'll be the same time. It'll be this channel. But hopefully it won't be another week before I manage to make a video. But we'll see. And yes, Delete Laws is in court, presumably for his trial on Monday. We'll see if he shows up. I'm not going to hold my breath, but he's going to be in trouble if he doesn't this time, finally. So that being said, I told you, even though we did 2 topics, it wasn't going to be a super long, because my voice still isn't completely back. So yeah, but I'm gonna leave it there. So thanks for joining me today. It was fun. I enjoy these cases. They're hilarious. I hope you guys enjoy them too. If you did, be sure to like, share, subscribe, bribe your friends and family to do the same. Join me next time. 43 minutes was the timestamp, right? That's what I'm going to go with. So that being said, thanks for joining me. Go watch Artie. I think he's starting in a couple minutes. I don't know what time Law and Lumber's starting, but enjoy the rest of your Friday night. Bye-bye.